The living trust bypasses probate. Chapter 1. The living trust. The living trust avoids probate. 1. The most common type of trust is known as the living trust. A living trust will help you avoid the time-consuming and expensive costs of probate. You don't have to be super wealthy to set up a living trust. A living trust will help you avoid probate, therefore keep your privacy because the probate process is public record. The living trust is not. A living trust is a simple concept. A trust is created by filing the paperwork. Assets are transferred into that trust. A trustee is named to manage the trust. This trustee can be the person who set up the trust, which is you. When you, the owner of the trust, die, the assets of the trust immediately pass to another party, thus eliminating probate. A living trust is the only legal solution to prevent lawyers from plundering your assets in the probate process. The information contained herewith may not apply in Louisiana, which operates on the Napoleonic Code, or community property states like Arizona, California, Idaho, Nevada, New Mexico, or Washington. Texas prohibits one person or entity from acting as all three parties, trustor, trustee, and beneficiary to a trust. In New York, you're unable to be sole trustee. You have to be a co-trustee with another person or institution to make investment decisions. The living trust is the most popular form of trust in America precisely for the fact that it can eliminate the time and cost of probate, which is the usual, government, court-managed method for the disbursement of an individual's estate after his death. Some people say, why not just put your major assets like your home, car, and bank accounts in joint ownership with a spouse or one of your children, and when you pass on, they immediately take full ownership of those assets. The problem with this is one of liability. If any of the partners in a jointly owned asset, not just you, are sued civilly or incur debts, the creditors can go after all the jointly owned assets as if they were owned by the one individual. A revocable living trust gives the grantor no asset protection because it is revocable, which means the grantor controls the assets, so if he or she has control, it means he or she can control it enough to pay their debts and judgments in the case of lawsuits. Even with this disadvantage, when you compare a revocable living trust with the probate process, in my opinion, there is no saving grace for probate. For anyone that has gone through it and there were some complications for one reason or another, it's horrible. It wastes time and money, and when all is said and done, often the only real winners are the lawyers who have trashed the estate in order to collect high fees. Some lawyers even prolong probate on purpose in order to collect more fees than when the estate has been trashed, they bail. In contrast, a living trust automatically avoids probate. You bequeath your assets in it. When you pass on, the trustee follows your orders immediately, and that's it. No wasted time in court, no probate fees, usually 4% of the estate, no sleazy lawyers, and it's not public record like probate is. One idea suggested to me by a savvy asset protection guy is to put all your assets into a limited partnership, which gives them protection from lawsuits. Then you get a living trust to own this LP. During your lifetime, these assets would be creditor and lawsuit proof. Then when you pass on, the assets would go to your heirs in a simple transaction through the living trust, which owns the LP. Be aware that several states have a rule that a homesteaded home transferred to a living trust loses its homestead protection status. A living trust can have a catastrophic illness provision wherein you state that if you become extremely ill, you want your assets given away to prevent Medicaid from getting it. This is a complicated, somewhat sneaky provision. Check with an expert if considering it. Since a trust is a separate legal entity from you, you can use them to insulate yourself against the cost of lawsuits and judgments. Unlike a will, a trust transcends state boundaries. It's good anywhere. In order to avoid family feuds, sit all your relatives down and talk to them in advance. There are do-it-yourself living trust kits out there, but if you have a substantial estate, get a good lawyer who can help you out. Don't just get any lawyer. Get one who specializes in estates and trusts. Probate can't be avoided with a living trust if there was a lawsuit or tax audit against you at the time of death. A shrewd way to save estate taxes is to set up a family partnership over all your assets with you holding most of the interest, and over time, transferring parts of your interest to other family members. You may want to change your living trust in the event of marriage, divorce, death of beneficiary, sale or purchase of property, birth of child. If you move from a common law property state to a community property state or vice versa. If you want to change executors and/or trustees. Make several copies of your trust and perhaps go to the trust department at your bank and show it to them to avoid any ambiguities later. You and your executor both must get all the paperwork ready. Document copies the trustee must have are signed copies of the will, codicils, and trusts. Income tax returns for the past 3 years. Gift tax returns. Real estate deeds. Bank accounts, CDs. Insurance policies. Stocks and bonds. Tax bills for property. All business transactions. Vehicles, boats, etc. Safe deposit box. Time shares. Membership in clubs, etc. Accounts and loans owed to the person. Financial statement. Debts owed. Death certificate. Funeral arrangements. Birth, marriage, and SSN. Hospital records. All states resided in. Children, where they live. Social Security benefits. Monthly expenses while alive. Monthly income. Prenuptial agreements. Written, audio or video instructions. Things the trustee should do. Determine the size of the estate. Check on all assets. Start insurance and Social Security claims. Review decedent's final instructions. Make a report of all assets. File income tax returns and inform them of death. Dispose of credit cards. Review all business contracts. Distribute assets and personal things. Order at least 6 death certificates. Honor last wishes if he was a former member of the military. He could be buried in a national cemetery for free if he wanted it. Determine payment of debts. Consider investing the assets wisely. Tell the relatives and friends what's going on. In the final analysis, your best bet is to go to your state's probate court and find out about the probate process in your state, then read up on both, talk to an expert and decide whether to go for a will or a trust. The living trust avoids probate too. A living trust is a legal instrument that can be used to eliminate the unnecessary costs of probate and prevent your heirs or surviving spouse from its exploitative nature. It's a tricky instrument because it doesn't automatically save your estate from taxes, but could if wise techniques are used and someone who knows about them counsels you as to which trusts to form and how to set them up. I read one article which views trusts as overrated and unnecessary for the average man and are often hyped up by lawyers to try to make money off them. Even if you set up a trust for some things, you still need a will to disperse the rest of your property, and this will go through probate. The biggest advantage is that what's in the trust stays private while probate is a public court case. The major benefits of a living trust are probate avoidance, minimal government interference, quick transfer of assets, privacy for your estate, saves on estate taxes, can save on capital gains taxes. Basically, a trust is an arrangement whereby an individual places all or part of his or her wealth, including property, in the hands of a trustee, lawyer, bank, trusted relative, yourself or friend, with instructions as to how to manage and distribute that wealth. The trustee is accountable to those who have an interest in the trust. They can challenge him if they feel he's abusing it. In its simplest form, a living trust is just another form of a will which you, the grantor, creates. You make yourself the initial trustee so that you can control it and change it if you want while you live, but when you die, the trust becomes irrevocable. Your successor trustee, either a friend, relative, or lawyer, takes charge of it and they disperse the assets according to your wishes in the trust without ever having to go to court, unlike the probate process required with a will. It's kinda like you relinquish ownership of your assets to the trust, but you still have total control over those assets. There are several different types of living trusts. With the simplest ones, your estate can be processed very quickly in a day to a few weeks, unlike probate with a will which could take up to 2 years. Some trusts are a little more complicated and may take more time to process, or they could be indefinite if they stipulate monthly payments to one of your heirs. A big myth is that the living trust will save you estate taxes. That's not true unless you have a smart lawyer who knows how to create certain trusts that can save on such taxes. One such trust is called a living trust with marital estate. Basically, the way it works is that with your spouse, you put money into a trust such that it is removed from your estate, thus lowering your overall worth, which translates into less or possibly no death taxes upon your inevitable demise. Nalo Press, 800-992 Nalo, 800-846-9455, Nalo.com, sells a book called Make Your Own Living Trust for about $20, which discusses this in detail. You could also check out number 346.73 of your local library for books on the subject. Theoretically, you're still subjected to the same income, estate, and inheritance taxes with a living trust as with a will. The big deal is that once you set up a trust, you can eliminate property in it from your estate depending on the type of trust it is and depending on who the proceeds of the trust are passed on to when you die. Hence, if you're smart about it, you can bypass estate taxes even if you have a large estate. Some drawbacks to trusts are the initial paperwork up front, transferring all your assets from your name into the trust's name, and possible hassles like insurance companies generally don't like to insure vehicles in trusts, nor do mortgage lenders like to give loans or refinance mortgages on a house that's in a trust. The person creating the trust is called the grantor, donor, or settlor. The person designated to oversee the trust, it will probably be you, initial trustee, and you will name someone for when you die. Successor trustee, is called the trustee. The person, group, or organization receiving benefits from the trust is called the beneficiary. A trust may be entered into while the person is living trust, or it may be arranged to take effect after that person's death, testamentary trust. A trust may be revocable or irrevocable. Testamentary trusts are usually made to manage the funds for children and other family members unable to take care of themselves. For example, something like, I give $100 a month to my daughter, Ellen, to be payable to her in cash, which will be increased to $500 a month on her 18th birthday. The successor trustee should be a trusted person who's doing this service because they want to. It's generally a lot of work, and you should make provisions in your trust to pay the trustee for his or her services. Talk to them in detail beforehand so they know what's expected of them. The trust can be either mandatory, which specifies clearly how the assets are to be distributed, or discretionary, giving the trustee the option to use his judgment when dispersing the assets. Though not legally required, a comprehensive trust which takes into account your entire estate should include all of the following. Living will, a right to die clause in case of medical incapacitation. A durable power of attorney, which means naming someone to take over the management of your estate in case you go incompetent through some event like an accident or mental illness. A catastrophic illness provision for your medical care if something happens to you. Assignment of furniture, furnishings, and all your personal effects, basically, like a residuary will where you sign over all the minor, miscellaneous things you own to one or a group of heirs. Appointment of a guardian for children, handicapped dependents, and elder dependents if applicable. You should also appoint an alternative guardian in case something happens to the original one. Appointment of conservator is a document wherein you assign a person to be your guardian in the event that you become incompetent for some reason. Organ donation if applicable, and finally separate property agreements as to how to disperse each of your major assets, real estate, life insurance, IRAs, safe deposit box, stocks and bonds, bank account, pension fund, etc., upon your death. The first step in making the trust effective is to transfer ownership or title of a property to the trust's name. It's safer to transfer the title to the trust's name rather than to the name of the trustee, since it is more likely the trust name will continue even if you change trustees. For the purposes of transferring title into a trust's name, there are two classifications of property. That which has an ownership document. That which doesn't. Property without ownership documents include the following. Household possessions and furnishings. Clothing and furs. Jewelry. Tools and most equipment. Antiques. Artwork. Electronic and computer equipment. Cash. Precious metals. Bearer bonds. These items are transferred to a trust simply by listing them on a trust schedule. That's it. Property that has ownership documents requires a re-registration of ownership into the trust's name. Once the trust document has been established, signed, and notarized, this process should begin. The document of the title must clearly show that the trust is the legal owner of the property, or the trustee will not be able to legally transfer any of that property. The type of property owned by the trust which requires this re-registration of ownership includes the following: real estate, bank accounts, stocks and stock accounts, money market accounts, mutual funds, most bonds, including U.S. government securities, safety deposit boxes, corporations, partnerships, and limited partnerships, cars, boats, motor homes, and airplanes. If you set up a trust and fail to re-register ownership of a specific property, it will remain outside the trust after you die. If you do not have a will, property will pass through intestacy and your state's succession law. The chances of leaving it to the person you wanted it to go to are reduced, and you will not avoid probate of the property, which is the purpose of a living trust. Do not fail to re-register property that has a title. You prepare a new title document for each piece of property, transferring ownership into your trust's name. With real estate, you must prepare and sign a deed listing the trust as the new owner. Then have the deed notarized and properly recorded. For bank accounts, ask your bank for the proper form. You can usually accomplish this in one trip. When you create a trust, your personal property changes ownership in a legal way. For example, a house owned by John Doe becomes a house owned by trustee John Doe of the John Doe Trust, assuming, of course, that he named himself as the trustee. You do this with all your assets. Transfer ownership from you to the trustee of the trust, you but a different, legal version of you assuming you're the trustee. If you don't do this, your estate will have to go through probate upon death. John Doe can still do what he wants with the stuff in the trust: sell it, paint it, spend the money in it, or give it away. He conducts business as usual and fills out ordinary income tax returns. Because the trust is revocable, you can change it or revoke it at any time. Anything not in your living trust could be subject to probate. Your living trust can include everything in the estate. You should put all your assets into a living trust, but also make up a will, called a pour-over will, to cover any assets you may have overlooked just in case, and to appoint a guardian if you have children under 18. The greatest advantage of a living trust is that your estate will be settled in 1 hour for no cost without probate, and your family can then grieve in peace and get on with their lives. Your best bet with a trust is to sprinkle your assets out to different relatives so that they don't get stuck paying high taxes on their gains. Wills can be easily contested and often are. Living trusts cannot. Wills generally simply divvy up the decedent's estate in a lump sum, one-shot deal, and that's it. A trust, on the other hand, can make provisions. For example, instead of leaving your son a $100,000 lump sum which he might squander, you could specify that he gets $10,000 a year for the next 10 years. Living trust warnings. Even in today's world of supposed enlightened people, with all the legitimate information out there telling you what's legal and right and what isn't, there are still scam artists coming onto the scene promoting all manner of scam trusts, and gullible people take it on face without doing any objective research. They lie to you and make it seem easier to save on taxes than it actually is. Many so-called experts give wrong advice and sell advice/forms that are useless. bbb.org/alerts/article.asp?ID =330 ftc.gov/bcp/conlany/pubs/services/livetrust.hdm ftc.gov nclc.org/initiative/seniors_initiative/avoid Living Trust websites: livingtrustnetwork.com, ustrust.com. 4 trustsoftware.com, Trusts and Wills Assembly Software, for attorneys only. attorneytrusts.com/article.htm. legalhelpmate.com/living-trust-online.aspx. livingtrustanswers.com. living-trusts.net. livingtrustnetwork.com. livingtrustsecrets.com. easytrusts.com. aribar.com/living_trust.html. fdic.gov/deposits/index.html. Rules for revocable living trust accounts. grandtimes.com/trust.html. heritagelivingtrust.com. ilrg.com/forms/trustdrive.html. revocable living trust, free legal form. living-trusts.net. savewealth.com/planning/estate/living trusts. willplan.org/living_trust_.html. Living trust basic form. This form creates a revocable living trust. Although touted as a substitute for traditional wills, a living trust also requires a pour-over will. A pour-over will bequeaths any assets which have not been conveyed to the living trust into the trust estate. Virtually all living trusts are revocable, which means that the terms can be changed during the lifetime of the settlor. Irrevocable trusts create extensive tax consequences and are not suitable for regular estate planning. Revocable trust. Underscore 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 underscore, referred to herein as settlor, and underscore 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 underscore, referred to herein as trustee. The singular term trustee shall refer to multiple trustees if multiple trustees are appointed, in consideration of the covenants and undertakings herein agree. Article I. Conveyance of property to the trustee. Settlor herewith assigns and conveys to the trustee the property described in Exhibit 1 hereto. All of said property, together with any income, accessions, and additions herein, shall be held by the trustee in trust for the purposes set forth in this revocable living trust. Article 2. Revocation. Settlor hereby reserves the right to revoke this trust at any time, by written instrument. Revocation shall be effective upon mailing or delivery to the trustee of a notice of revocation. Trustee may resign upon 30 days prior written notice to the settlor. For purposes of this agreement, notices shall be delivered as follows. To settlor. Write in your, the settlor's, name and address below. Underscore 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 untrustee. Write in the trustee's name and address below. Underscore 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 Article 3. Successors to the trustee/additional trustees. The settlor during his lifetime may from time to time add additional trustees by notice to the then existing trustees. In the event there are multiple trustees, the majority shall in any matter in which the trustees disagree control. In the event that the trustees are evenly divided in the actions to be taken, the trustee with the longest tenure of service shall cast an additional vote to determine the matter. In the event that any trustee resigns or is unwilling or incapable of acting, during the settler's lifetime, the settler shall name additional or replacement trustees. After the settler's death, underscore 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 shall name the replacements for any trustees who resign or are unwilling or incapable of acting. If underscore 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 is unwilling or incapable of acting, underscore 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 shall name the same. In the event that underscore 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 shall be unwilling or incapable of acting, the court having jurisdiction over states and trusts, located in underscore 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 county, state of underscore 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 shall name the successor trustees. Article 4. Withdrawals by settler. The settler may from time to time withdraw any portion of the corpus of the trust, whether capital or interest, by written notice to the trustee. The trustee shall be acquitted of all further responsibility for any assets so delivered upon receipt by the settler. Article V. Powers of the trustee. The trustee shall have the power to do all acts, institute all proceedings and exercise all rights, powers, and privileges that an absolute owner of the trust property would have, subject always to the discharge of trustee's fiduciary responsibilities. I further direct that the trustee shall act without bond. Further, this trust shall be administered without the necessity for an administration thereof to be through the court system. No entity dealing with the trustee shall be required to investigate or to confirm the trustee's authority to enter into any transaction or to administer the application of the proceeds of any transaction. Article 6. Compensation of trustee. If the trustee is an individual, then the trustee shall serve without compensation but with reimbursement for reasonable and ordinary expenses. Nevertheless, the trustee, if an attorney, shall be entitled to compensation for legal services rendered to the trust, or if an accountant, for accounting services rendered to the trust. If the trustee is a corporation or banking entity, it shall be entitled to customary, reasonable, and ordinary charges and expenses incurred in rendering services to the estate. Article 7. Disposition of trust proceeds. After paying the necessary expenses incurred in the management and investment of the trust estate, including compensation as provided for herein, the trustee shall accumulate the same during the lifetime of the settler. After settler's death, the trustee shall distribute the net income of the trust in the manner specified in the trust. Should any beneficiary named above die, the trustee shall distribute the net income to the lineal descendants of the beneficiary. If any beneficiary dies and is not survived by lineal descendants, the distributions from the trust shall be adjusted to pro rata increase all other shares. Article 8. Invasion of principal. After settler's death, the trustee may apply so much of the principal of the trust for the use of the beneficiaries at such time or times as in trustee's discretion trustee may deem advisable for their health, education, support, or maintenance. Any amounts so applied to the use of any beneficiary shall be charged against or deducted from the principal of any share then or thereafter set apart for said beneficiary. Article 9. Non-assignability of the trust proceeds. The interest of the beneficiaries of this trust shall not be assignable, and beneficiaries shall not have the right to pledge, assign, convey, or otherwise transfer, lien or encumber any portion of the income or principal of the trust. All payments provided for by the beneficiaries herein shall be made directly to them or their guardians as is provided herein. Article X. Distributions to minor or incompetent beneficiaries. The trustee in his discretion may make payments of income or principal to any minor or incompetent beneficiary by paying the same to the minor or incompetent's guardian or to the person having control over the minor or incompetent, or by direct expenditure for the benefit of the minor or incompetent. However, the trustee may also pay an allowance in such amount as he may see fit from time to time to the minor or incompetent. Further, in the discretion of the trustee, the distributions for a minor or incompetent beneficiary may be accumulated and shall thereupon be paid to the minor or incompetent upon their disability being removed. Any payment under this section shall operate as a full discharge of the trustee as to such payment. Article 11. Accountings. The trustee shall, after the death of the settlor, provide a semi-annual accounting to all competent, adult beneficiaries detailing the transactions, if any, of the trust. The same shall not be required to be audited, although the trustee may, in his sole discretion, may cause an audit to be performed from time to time. Article 12. Liquidation of trust. If at any time the total of the principal and income of the trust is less than $500,000, the trustee may, in his absolute discretion, close out the trust by paying the proportionate shares of each beneficiary to them. The trustee shall at that time deliver a final accounting to each beneficiary. Upon payment, the trustee shall be discharged from all further duties. Article 13. Perpetuities Savings Clause. Notwithstanding anything to the contrary herein contained, the trust created by this agreement shall cease and terminate as is provided in sections 9, 21 years after the death of the last survivor of trustors and all issue of trustors living at the date of this agreement. Article 14. Distribution of division in kind. On any distribution from the trust, whether it be an ordinary distribution or one of principal or a final distribution, the trustee may apportion and allocate the assets of the trust estate in cash and partly in kind, in trustee's discretion. The valuation, whether based on an appraisal or not, made by the trustee shall be binding on the beneficiaries. Article 15. Litigation or compromise of claims. The trustee may compromise or abandon, at trustee's option, any claim or claim against the trust or subject the same to arbitration. Or the trustee, in his absolute discretion, may litigate any claim in favor of or against the estate. Article 16. Notice of events. Until the trustee receives notice of any death, birth, marriage, or other event on which the right to receive distributions is based, the trustee shall incur no liability for any disbursement or distributions made in good faith. This clause shall not prevent the trustee from seeking restitution of any payments made in error in his discretion. Article 17. Definitions, Governing Law. The words child, children, descendants, and issue shall include children legally adopted and the lawful descendants of such adoptees. This trust shall be governed by the laws of __________________________________________________________________________________________________________________ put state here. Article 18. Severability. If any provision herein is found by a court of competent jurisdiction to be invalid, the remainder shall govern. Dated Put the notary public's name here State of county of Notary public's name here being duly sworn states that they executed this instrument for the purposes stated herein. Notary Public. My commission expires. Underscore 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 underscore.